Thank you very much.
So thanks a lot, Matteo. Thanks, Giuseppe. Thanks to Stals for inviting me today. It's really a pleasure and an honor to be back basically here where everything began. Actually, this book is based on a PhD thesis that Giuseppe directed. And it's thanks to him, I really have to thank him if he pushed me so hard to go to the next level and to turn the thesis into a book, which is the book that I'm presenting today. Islam, Constitutional Law and Human Rights, Sexual Minorities and Freethinkers in Egypt and Tunisia. So today, could you just confirm if you see my screen? Yes, perfect. So today I will try to present it as briefly as possible, both in its content and a couple of words about the methodology. First of all, what did I try to do with this book? My research question was to explore what is the interplay between Islam, both in terms of Sharia law, but also in terms of cultural references to Islam in a constitutional document, and on the one hand, and individual liberties on the other hand. How do they interrelate with each other? How does Islam affect individual liberties? To do that, my book follows a structure from general to particular, starting from a general assessment on Islam, constitutionalism, and human rights, then zooming in ratione loci on Egypt and Tunisia, and then even further down ratione materiae on the rights of homosexuals and freethinkers. And with freethinkers, I mean blasphemers, apostates, heretical, so all those that are outside the norm of Orthodox Islam in Egypt and Tunisia. So this is just the outline of my book that follows the structure that I told you. There are 8 chapters besides the introduction and the conclusions. A few words of methodology. I've sometimes heard the joke, even at Sant'Anna during my PhD, that legal scholars don't actually have a methodology. I don't know if this is true, but for sure I followed mainly a basic black letter law methodology, so an assessment of legal provisions with this sort of addition of what is called law reform research, meaning that my aim was not just to analyze in vitro these provisions, but also to try to offer perspectives of improvement for human rights. I based my analysis on literature, of course, but also on primary sources that I collected during 2 stays in Egypt and Tunisia. I accessed original case law, and I also interviewed a plethora of different actors, lawyers, victims of human rights abuses, members of civil society organizations, judges, doctors. So I really want to thank all those that participated into this project, because they constitute the real added value for me of this project. What's very important for me to stress is that I followed an empirical approach. What I wanted to do was to analyze certain norms to see how these norms are interpreted in light of Islam, and whether this interpretation of Islam makes them compatible with human rights. I'm not a religious scholar, so I cannot take any stance on the abstract compatibility between Sharia and human rights. I cannot claim that I have the answer of what the real Islam is, the real Sharia is, because clearly that's not my competence. And by the way, from a non-believer perspective, what I can confirm is that it's kind of difficult to say what Sharia says, because Sharia is a stratification of different meanings and interpretations throughout the centuries. So this is a necessary caveat for my study. Starting with the first part, Islam, constitutionalism, and human rights, what I attempted to do in this first chapter is to give a brief overview of the conception of power in Islam and the legitimacy of power in Islam. Of course, I couldn't delve into the specifics and the nitty-gritty of these very complex issues, but I tried to give a historical and conceptual account of what of what power and just government means in Islam. So what emerges strongly is that the legitimacy of power lies in God, which means that the legitimacy of the ruler depends on the observance of Sharia as the law of God. And two important consequences of these are that the ruler is not bound by earthly requirements, such as a human-made Bill of Rights. And it also means that the ruler himself cannot establish a human-made corpus of law if this goes against the rule of Sharia. As it has been said with an efficacious expression, the Islamic government is bound by law, but not by the rule of law. And when we speak about law, we speak about Sharia law. Does this create problems? Well, from a human rights perspective, yes, in the sense that Sharia, as interpreted in its orthodox way, presents certain key issues that go against the sensibility of modern human rights and also international human rights law. And this is pretty much shared by many scholars. What are the areas where Sharia is problematic? Traditionally, Islam knows three grounds for discrimination between Muslims and non-Muslims, between men and women, and between free men and slaves. The last one, at least formally, has been abrogated throughout the Muslim world. The first two remains, and they need also to be added to another series of issues, such as the prohibition of torture when it comes to Quranic or hudud penalties based on Quran and Sunnah, that are the notorious flogging, amputation, stoning to death, etc. Freedom of religion, including apostasy from Islam, because apostasy is considered Muslim countries. Freedom of expression in relation to blasphemy, but also to heresy, so to the attempt to reform Islam, and this is very crucial. And sexual freedom, including issues such as premarital sex or homosexuality. Now, in the following chapter, I wanted to see how this applies actually in concrete by analyzing certain charters of human rights and the Al-Azhar constitutional project. Why did I do so? Because these are documents that are not actually implemented, that are not state law. So these gave me a sort of theoretical idea of what Muslim thinkers, Muslim intellectuals, or a very well-renowned institution such as Al-Azhar consider in terms of human rights and compatibility with Sharia. And the analysis of these documents confirmed that there is a tension between Sharia and human rights in all the postulated domains. So less rights for women, blasphemy is prohibited, apostasy is prohibited. Now I'm making, of course, a summary for reasons of time, but more or less these documents, they all share this apparatus. And what they also share is that individual freedoms cannot trespass the limits set by God. Now, going into the constitutional assessment of Egypt and Tunisia, first of all, a couple of words of why I chose these two countries. Because they are the main protagonists of the Arab Spring, and also they followed a similar trajectory when it comes to the constitutional path. There was in both cases a powerful Islamist camps constituted by Muslim Brotherhood and Salafis, and their opponents, more or less secular, more or less liberal, more or less leftist forces. And the outcome was clearly very different, but what we can see are some parallels in the constitutional drafting. Now, when it comes to Egypt, Egypt is an important country because it constitutes a constitutional theocracy, meaning a country that has a formal system, a formal constitutional system, but a Sharia supremacy clause since 1980. The principle of Islamic Sharia since 1980 are the main source of legislation according to Article 2 of the Constitution. Now, what I did, I analyzed the interpretation of this article rendered by the Constitutional Court, and what emerges is actually a tension between two different ground norms, Sharia, the law of God on the one hand, and the Constitution on the other. But the problem is both formal and substantive. Formal because Sharia, as I was mentioning at the beginning, is not a codified corpus of law. And substantive because these can give rise to serious human rights violations. Just an example for all, the Supreme Constitutional Court has stated that among the fixed rules of Sharia that cannot be abrogated and to which the Egyptian legislation must conform is, for example, the right of the wife to obey her husband, just to make an example of what I mean with human rights violations. Now, I dedicated a part of my analysis to the 2012 Constitution that was adopted by an Islamist assembly, because here we can see an expansion of the purview of Sharia in key domains. The religious University of Al-Azhar was to be consulted in all matters related to Islamic law, so basically it became a third non-elected chamber. There was the attempt to crystallize Sharia in its orthodox interpretation to avoid the reformist interpretation of the Supreme Constitutional Court. Blasphemy was prohibited. No specific provision on women's equality. Women were just called sisters with men, and to be like highly praised or something like that, but no mention of their rights. And also the surreptitious attempt to introduce Quranic penalties into the system. Now, what emerges with the 2014 Constitution that was drafted after Morsi's government was ousted by the army following massive demonstrations is that formally we are before a text which is much more in line with international standards, although we still have the presence of two problematic issues, namely the retention of Article 2 and also the privilege for the religions of the book, meaning that only Muslims, Christians, and Jews are authorized to manifest their religion in Egypt. When it comes to Tunisia, as I was mentioning before, we see similar dynamics. Ennahda, which is the party linked to the Global Muslim Brotherhood, along with other Islamist parties, try to basically push for what Morsi did in Egypt, namely the constitutionalization of Sharia, which is not present in the Tunisian constitution, the institution of the High Shariatic Council to check every piece of legislation to see if it's actually compatible with Sharia, the explicit reference to Islam as the religion of the state, the ban on blasphemy, and the attempt to replace women's equality with women's complementarity with men. They didn't succeed because of the more secular civil society, because of what happened in Egypt. And so the final text, at least for now, because now probably it will be amended again next June, but what the text that is now in place is a sort of equilibrium between Islamist and more liberal stances. And maybe I selected these three examples because they are really emblematic. In Article 1, for instance, we say that Tunisia is a free, independent, sovereign state. Its religion is Islam. And in Arabic, its can refer both to Tunisia, so with a descriptive social value, or to the state, so with a prescriptive value. And this actually was the article already in place before the present constitution. And then Article 6 is another emblematic one. The constitutionalist Yad Ben Ashur has called it the pupurri of the Tunisian constitution because you can find there everything. The state is the guardian of religion, but at the same time, it guarantees freedom of conscience, and freedom of conscience is very crucial, especially in an Islamic context, because it includes the the theoretical possibility of criticize religion. Then we have the protection of the sacred, but also the ban on excommunication calls that are actually death threat in an Islamic context. So you can see that the Tunisian constitution is really an equilibrium of ambiguities that were the only way actually to keep the agreement on the final text. Now, let's go quickly into the case studies. Why did I select homosexuality, blasphemy, apostasy, heresy? Because they are certainly the most problematic issues in an Islamic mindset. So not even hardcore Salafists would deny that women have rights. Maybe they have a very peculiar understanding of women's rights, but still they recognize the presence of certain domains of human rights. When it comes to these issues, even legal scholars, even Muslim legal scholars, tend to consider them as sort of marginal questions that go against the sensibility of society and therefore remain outside any legal protection. But another interesting finding that actually I discovered during my research is that there is a very strong conceptual association between these two key issues. They are punished under the same vague nomina iuris, public morals, public order, decency, general sensitivity. They are punished by making reference to the sensibility of the majority, so with a complete disregard for minorities' rights. And there is also, even in those cases that do not have necessarily a religious component, such as homosexuality cases, there is often the reference to religious terms, deviations, form of Satanism, fitna, meaning the disgregation of the social fabric, but it's another religious term. So we can see a very strong conceptual association between these two categories of people that are really at the margin of society. From a legal perspective, what we also see is that there is a pronounced vagueness. So, for example, in Egypt, there is no explicit ban on homosexuality, but only on debauchery that in theory, in the original law referred to prostitution. In Tunisia, there is a ban on male and female homosexuality, but it's not clarified whether it's about certain behaviors or the mere identity. We don't know what decency, public morals, public order are. Of course, these are present as well in the Western context, but the way these concepts are filled in the Islamic mindset is particularly liberticidal. So the consequence of all of these is that any deviation from the norm can be criminalized. Even pure personal identity, the fact of unveiling oneself as homosexual, the fact of having a effeminate appearance, the fact of belonging to an unprotected sect, such as the Baha'i. So, and here we are talking about identity, not conduct. Expressions of individual conscience, the mere fact of declaring one's atheism, or of being blasphemous, or of supporting from a human rights perspective these categories. And finally, what's very important for me is that even academic research or attempts to reformism can be qualified as heresy and therefore as apostasy, and therefore lands you in jail, even if you don't attack the faith itself, but you're trying to reform it. And this is what makes Sharia particularly dangerous where it is in place. Now, in the final chapter, I assess these issues against the constitutional provisions in Egypt and Tunisia and against international law. What emerges is that in international law, the Human Rights Committee and other bodies are very unequivocal in clarifying that homosexuality, blasphemy, heresy are all issues that should be allowed in both by customary law and by the affiliation, by the state signatories to the International Covenant on Civil and Political Rights. But also the constitutions of Egypt and Tunisia would be equipped theoretically to guarantee the rights of these categories of the population. So to go into my conclusions, and to summarize a bit what I've just said, Islamic constitutionalism presents a fundamental aporia. What is to prevail, a religious source, God's law, or a human-made source of power? And this legal antinomy creates, even on the practical level, a discrepancy between rules and principles that actually refer more to a liberal tradition, and others that instead go back to Sharia. This would not necessarily be a problem, as I was mentioning before, if Sharia could be easily reformed, but this is not the case. The prevalent interpretation of Sharia law is, as it is interpreted now, is incompatible with some key fundamental rights, and therefore it goes against the idea of modern constitutionalism. Certain categories of the population are especially vulnerable to these human rights violations. And what's also important to remark on the basis of the Tunisian case is that the explicit mention of Sharia in the constitution and in secondary statutes is not a precondition for the surreptitious application of its norms. And NACTA speaks of a state with Islamic reference, for instance. So my main conclusion is that a religious group norm, no matter what religion, is incompatible with the primacy of a human-made constitution and with the full recognition of inalienable individual rights that embody the constitutional mission. Especially, I want to remind that a constitution is about the protection of minorities, not the enforcement of the will of the majority. Individuals, as Ayn Rand used to say, are the smallest minorities on earth, and the constitution should protect the rights of all individuals. So thank you for your attention, and I'm now very much willing to reply, to listen to Pasquale and maybe to Marwa if she's here, and to reply every other question.
Thank you very much, Tommaso, for